Hello, and welcome to One-on-One with Robert Doar. I'm your host, Robert Doar, and thanks for tuning in today. As president of the American Enterprise Institute, I have the unique privilege of working with America's greatest policy experts. These scholars focus on policy issues in the fields of education, economics, energy, foreign and defense, and so much more. Subscribe to this podcast for exclusive access to in-depth discussions on the most pressing policy issues. Together, with my guests, we'll challenge political preconceptions, explore innovative ideas, and create, I hope, a freer and safer world. Okay, we're back with Adam White, Part 2. The court's term this year was so extensive and so dramatic and so, for some of us, spectacular, that I think it needs extra attention, and that's why we've asked the great Adam White to return for Part 2 of a discussion of this year's term. Adam, thanks for being here.
Well, every blockbuster deserves a sequel, Robert.
That's right. Okay. Now, in Part 1, we spent a little bit of time on Trump versus the United States, which was the immunity case.
Yep.
And I was sort of hoping I could just end with that and go on to the two other cases I want to talk about. But there's one thing I was sort of left unaddressed that I wanted to ask you about. And as you will recall, Adam, we talked about how Justice Roberts divides the president's immunity into three categories. He's fully immune, absolutely immune, from official acts that reside within his core duties, his or her core duties. And the best example of that is his appointment power or his ability to pardon. He's immune for actions concerning those official duties. He's presumptively immune, which means he's not entirely immune, but he's presumptively immune for official acts that are non-core, and then he's not immune at all for private acts or non-official acts. So we asked about certain scenarios in the last conversation. I want to add one more, and that is President consults with and directs campaign officials who are not executive branch employees to suborn perjury or to obstruct justice. Yeah. What say you on that?
So I was such a bad answerer in the first episode, but I just have to ask, when you say campaign officials, do you mean officials in his presidential campaign, or do you mean like Georgia election officials, that kind of thing?
I meant people who are employed by the campaign. I've spent time in politics. I guess, Adam, maybe you haven't. Sometimes you're with the boss over in the executive branch at his office, or other times you get dispatched and you go over and work for the campaign.
Yeah.
I'm talking about those kinds of people, okay? The people that are over at the campaign.
Yeah, that's like sometimes I'm here working with you, and sometimes I'm working with Jason Birch. He's the campaign.
Yeah.
But no, it's...
Yes.
Yeah, so it's...
Okay.
Okay, but to answer your question, that's an easier scenario. Obviously, the team on the president's presidential campaign, they don't have any official duties. The president, when he talks to them...
They're not executive branch employees.
Right,
that's my point.
Yeah, that's right. That's right. That's right. They're not executive branch appointees. But the thing is, Robert, and why I asked about could campaign officials be Georgia state officials, that's a little trickier, right? The president might talk to them in his law enforcement capacity.
Or in his bully pulpit capacity.
In his bully pulpit capacity,
yes.
Which I thought the opinion overstated a little bit, but I digress. In this case, campaign officials, that's to me a very, very easy case. I can't imagine a scenario where that's not just a private action, no immunity.
So, and that reminds me of, when you work for a state legislature, as I did at one point as a staffer, and you are, for instance, sometimes they get into weird discussions like where was the phone call take place? What tool did you use? You use a campaign phone or a government phone? So there are distinctions where a judge could say a president directing campaign officials who work for his presidential reelection campaign can be prosecuted and convicted for actions that are against the law.
Yes.
Okay. So those of you out there that are worried that this decision exempted presidents from doing things that maybe some in the past have done that were thought of as illegal and are no longer illegal aren't correct. Isn't that right?
Yeah. The reason why I'm starting to laugh to myself is this case and the framework, which, again, I think Robert's got basically right. It just invites the most insane hypothetical questions. Here's one for you. Obviously, if a sitting president is talking with his own campaign's officials about the campaign, that's obviously a private act. What happens if a sitting president who's also running for re-election, reaches out to people in his opponent's campaign and tries to get them to stop doing things in favor of their own campaign, would that be him in his capacity as a candidate? Or is that him in his capacity as a law enforcement officer? I'll leave that to the audience to ponder.
Yeah, you're right. That's all to be decided in the future.
Someday.
Okay. So that's it for Trump versus the United States. Now we want to turn to a decision that was just recently handed down by a federal district court judge in Florida, Judge Cannon, who's been handling the President Trump's documents case. This is the case where he took a lot of documents that he really wasn't supposed to have, and there was a lot of back and forth, and they ended up executing a search warrant and recovering the documents, and he was being prosecuted for failing to tell the truth to the FBI and to law enforcement officers and for keeping documents he shouldn't have. Mm-hmm. Judge Cannon has now ruled that, leaving the merits aside,
right,
the appointment of Jack Smith as the special counsel violated separation of powers. There's not a statute on this. What's going on? What is she doing here?
Yeah, and with everything, all the Supreme Court cases out there, everything going on in the world, I'm just boning up on this decision, so I'm going to be a little bit vague. But in general, there were two parts to the holding. The first one, at the very end, and I'll just get it out of the way, is that this prosecution violates the Constitution's appropriations clause. Congress and the executive branch can only spend money that Congress has properly appropriated under the law. That was actually the subject of another case this year involving the CFPB. And as Judge Cannon points out in her decision, it's not clear that Congress has actually appropriated money for special counsels like this. There's a statute out there that would, and again, I read this very quickly so far, but if I understood it correctly, there's a statute out there that would justify an independent counsel spending money under the old independent counsel statute. But of course, that statute doesn't exist anymore. So the question, and Cannon ultimately concludes the conclusion, is that any money spent on this prosecution is unconstitutional. That's a very, very brief part at the end of the opinion. The heart of the opinion is the appointments clause. Article 2 of the Constitution gives the president the power to appoint officers. The president appoints them. The Senate gives advice and consent. There's a subset of officers we call inferior officers. They're like the Jason Birches of federal government. They're not the big boss, but they have a lot of power. For those inferior officers, normally the president appoints with the Senate's advice and consent, but Congress can pass laws when they create the office, allowing the president to make the appointment alone, and there's more to it than that. But anyway, that last part, when Congress creates the office, that's the key to this opinion. As I understand it, Judge Cannon held that the Office of Special Counsel was not created by a statute. Of course, it was created by, in effect, a Justice Department rulemaking after the independent counsel statute expired. But that's just the Justice Department. Cannon says that for this kind of role in the government with this kind of power, the job had to be created by Congress, just like so many other jobs in the executive branch, not just the Attorney General, but the Deputy Attorney General, the Solicitor General. U.S. attorneys' offices over and over again are created by statutes, and Cannon says this one needed to be too.
Well, so that raises the question of, weren't there previous special counsels or special prosecutors?
Yeah, there's been a few of them.
Who have been in work and their cases went forward and judges ruled on all sorts of issues about them, but the previous judges did not rule them unconstitutional. Was that because it was never brought or pled, or is it because other judges have ruled differently?
It's a good question. I think it's because it hasn't been raised. I don't think there have been cases going the other way, but I could be mistaken.
And this will be appealed,
yeah,
I presume.
Definitely.
And the 11th Circuit, a 3-judge panel of the 11th Circuit will be assigned and will review it and make a decision. But I guess it does. I sort of forgotten that the independent counsel statute expired. It does no longer exist.
Yeah, it expired around 2000, I guess. And the regulations for these special counsels was created, that's right, by the Reno Justice Department. Former Solicitor General Neil Katyal often sort of takes public credit for having written those regulations, and it was to fill a gap. Can I just point out the irony of this, all this? Let me start with the historical analog. Remember when President Obama was making the case for what became Obamacare, and Republicans would criticize him over and over again, said if you put in this individual mandate, it would be a tax and you promised not to raise anybody's taxes. And Obama said in a highly public interview, no, this isn't a tax. Well, then, of course, once the law was on the books, everybody switched arguments because suddenly Obama needed to argue, his administration needed to argue that it was a tax so it could survive constitutional review. And Republicans were arguing, no, it was not a tax for constitutional cases. Something very similar is happening in this case. As the case got started, the Justice Department would say over and over again that Jack Smith is independent. He has all of this power. He's not being micromanaged by Attorney General Merrick Garland in order to keep this independent from politics.
Oh, I see.
And often the political attack on Smith was, no, he is not independent at all. Merrick Garland still has full responsibility for this. Once it becomes a legal constitutional issue, everything flips. And so ironically, it's the Justice Department making the case that actually Jack Smith is not that independent. And it's Jack Smith's critics who said, oh, he's totally independent. I remember tracking oral argument around this issue. There was a very widely publicized and long set of oral arguments around this issue in Judge Cannon's court. And I remember just thinking of the irony that the Justice Department was saying, well, actually, Merrick Garland is still firmly in charge of this prosecution. And so here we are. Who doesn't love a little irony?
I guess I love a little irony. I guess I do. The sad part for me is just it's another thing that the American people will look at and say, does anybody around here know how to play this game? It just seems like a mess, and that includes people that think that what President Trump did was really bad with the documents, and people who think what he did wasn't bad at all. But now it looks like it's all hooey.
Yeah. Well, that's true. And I frankly always thought that the documents case was the strongest case against him. I've never bought this argument that he could just wish some things into declassification, let alone that he actually did wish it into declassification. This always seemed like the strongest and most straightforward case. Robert, there's one last thing. I don't want to nitpick your run-up to the question, but when you said this would get appealed to the 11th Circuit, normally that is what would happen in the ordinary course of business. As we record this, there's been no word on whether the Justice Department will try to leapfrog the 11th Circuit and go straight to the Supreme Court on some kind of fast-track emergency appeal. That wouldn't shock me at all.
Well, but that also raises, you said the Justice Department, Jack Smith, would he be required? How would the Justice Department view Jack Smith's decision-making process on whether to appeal or how to appeal? Is he consulting with the Home Justice, or is he doing it on his own? How would that play out?
That's a good question. I don't actually know.
Yeah. Okay. We'll come back to that maybe another day. But let's move on to something that I think is more positive, coming from my background in social services. The Ninth Circuit out in California had issued a ruling saying to cities and towns, like this, not unlike the cities and towns I used to work for, that they could not outlaw camping by homeless people who were deciding that they were homeless and needed to set up camp in a park or a town street or somewhere. And that sort of paralyzed a bunch of towns and cities that were trying to regulate camping and where homeless people were allowed to sleep at night. And so they sued and went all the way to the Supreme Court, and Justice Gorsuch wrote I think a really marvelous opinion about this that covered a lot of sort of social services topics.
Right.
And tell us about what Justice Gorsuch is doing there and the history of this case and what your view of the constitutional issues.
Yeah, well, I think the court basically got it right. The crux of this case was that the Ninth Circuit had held that these laws prohibiting what's the term they use? They didn't say vagrancy, but basically what we call vagrancy. They were camping at people could camp out in public places, sleep on park benches, sidewalks, that kind of thing. The Ninth Circuit said that violates the Eighth Amendment's prohibition against cruel and unusual punishment. And what the court held was that amendment really only applies to the punishments that are imposed after you're convicted. It doesn't put a limit on what can be criminalized in America. And that's not a novel argument. That's basically been a textualist reading of the Eighth Amendment for a very, very long time, and I think it's right. But there's a fly in the ointment of the Supreme Court's precedents. It's what complicates the issue enough to give rise to this case. In 1962, the Supreme Court, in a case called Robinson versus California, the court held that California couldn't just criminalize addiction to narcotics. They said you can't criminalize a status like that. The Eighth Amendment prohibits that. Now, the court now, in this new case, Grants Pass, does throw some shade at that case, says it's not clear that that's really a good textualist reading of the Eighth Amendment, which, again, we read to focus on punishments after conviction of crimes, not a limit on defining the crime in the first place. But the court didn't roll back that precedent. They said nobody's asked us to. In a subsequent case called Powell versus Texas in 1968, the Supreme Court itself had already sort of cabined that prior case by saying, yeah, you can't criminalize being addicted to a narcotic, but you could criminalize actions based on that. You can, it's not illegal necessarily to be an alcoholic, but you can criminalize people being drunk in public or doing damage or driving a car drunk. And so the court ultimately holds that it's perfectly constitutional for the states to criminalize this kind of thing. They don't have to criminalize it, but they can. And the court, in a very Robert Dorr-spirited paragraph, says all the considerations around this issue, how to define the limits on a state in city in criminalizing this or not, all the questions about, well, what kind of services would the state have to provide and the person turn down in order to allow them to the state to criminalize it. That's the kind of stuff a legislature needs to hash out. Now, the dissenting opinion by Justice Sotomayor begins with a line that I think was thrown around in oral argument too, that sleep is a biological necessity. You can't criminalize sleep. And the majority says, well, that's not what's happening here. No one's criminalizing sleep. They're criminalizing sleeping in public places. Now, of course, if you're homeless, you have to sleep somewhere, sometime. And so I don't think the court was downplaying that, but they were saying this is not the kind of issue for which the lower courts or the Supreme Court should be micromanaging legislatures.
Yeah, so I thought this was one of those classic cases where the progressives on courts, like those in the Ninth Circuit, could create a new right out of whole cloth on something important and difficult and challenging, like how to care for the homeless, that could hamstring and upset the common sense application of policy at a local level for thousands of cities and towns all across the West, all across the United States. And what I found remarkable about Justice Gorsuch's opinion was how the use of the Eighth Amendment's prohibition against cruel and unusual punishment was just out of thin air brought up by the Ninth Circuit. It had never been considered in that context ever before. They did it, and then he documents the number of cities and towns, including very liberal, very progressive towns, San Francisco, that fiercely objected to this prohibition, that hindered their ability to provide appropriate care for people who were camping out in streets and parks in their towns. And so it was like the people uprising against, the elite court, telling them how to do their business based on a right that had never been recognized before. That's a pretty fair summary?
Yeah, that's a fair. I wasn't following the press coverage of the case too closely, but I do know that cities, very blue cities in very blue states, their governments, their mayors were often the ones arguing that the Ninth Circuit had overreached. Something that might have been in the back of the judge's mind, I can't remember of the justice's mind, and I can't remember if they cited this or not. Years ago, state Supreme Courts under state constitutions would often take a broad right in the Constitution. Sometimes there's a right to a free and equal public education, especially in the aftermath of Brown versus Board of Education. Sometimes states or state judges would point to that kind of broad constitutional right under the state constitution and really start to micromanage the schools, right? Really getting down into decisions about the conditions of the buildings and spending and curriculum and so on. And those were all state cases under state constitutions, but any of us watching those cases could see how what the judges were doing started to look less and less like being a judge and more like being a legislator. And it often becomes total chaos. And so even if the Supreme Court didn't invoke those cases explicitly, they were prominent enough 20, 30 years ago. They're probably in the backs of some of the justices' mind.
The other thing I would point out, Adam, is that Justice Gorsuch took some time to talk about the problem of homelessness in cities and towns in America, and in a way that was not particularly judicial. It was almost like a sort of quick dissertation on the policy and issues concerning the homeless.
Yeah.
And one topic that he brings up, which I'm familiar with, is that something like 70% plus of people who were camping out or residing on the streets outside of temporary shelter had declined the offering of temporary shelter by the municipality. And this is a big problem, is that people seem to think that, well, they're there because there's nothing available for them in the provision of services by the city or town. And that's just wrong. Yeah. They're sometimes very elaborate. It's not a middle-class residence, that's for sure, but it is a temporary shelter that is safe, that is drug-free, that might have some rules, but it's a bed, and it might even and often comes almost certainly with the provision of food and even medical care. But people on the streets are declining that in order to reside, in the park or on the, in a tent in some town, and the towns are saying, look, we've made the effort to provide appropriate care for these individuals, and they're declining it, and we ought to be able to not allow them to do this in our towns when we at least have the services. And I felt that was sort of heartbreaking, and also described how problematic homelessness is. And to have the policy that's needed to address it be determined by judges using, an absolute right, it seemed to me was not very practical.
Yeah, I thought that part of the court's opinion was really even-handed, and as you said, it tried to take seriously both the plight of homelessness and the sources of the current situation, and the efforts of local communities to fix this, and the interest of local communities in fixing this. It really struck me as exemplary of Justice Gorsuch's own kind of style. He, in a number of opinions, most recently involving Native American tribes, the McGirt case and so on, and when he was on the 10th Circuit, cases involving Chevron deference, as we discussed before, but in cases involving immigrants and so on. I've always been struck by the way he goes out of his way to really grapple seriously with the human dignity of people involved in these cases, even when it's not dispositive on the actual outcome of the case. Just his style as a writer, as a judicial writer, I think really emphasizes human dignity.
Yeah, I agree, and I think that I've talked to a lot of people about. I get asked from my background, where can I read something interesting about poverty or homelessness or childcare? Justice Gorsuch wrote as if he was someone who knew something about these issues, and he wrote with some care and depth, and I appreciate it, and I think it should get some attention. Okay, now we turn to the last case for us to discuss, which is Murphy versus Missouri, which is I'm a former newspaper editor, Adam, and when I was a newspaper editor, when we would publish things, occasionally we'd get phone calls from, people that were covered in the story, people that worked in the government. I was local journalism, but it would call and say, you got that wrong.
Yeah.
You ought to fix that and clean that up. With the rise of social media and the explosion of information that's on these platforms, some government officials have tried to treat social media platforms like Facebook or others is sort of like their newspaper organizations or television stations that they could call and badger and say, you got that wrong, fix that.
Yeah.
But that's raised issues of censorship and government intervention and the right to free speech. And a case was brought that really challenged that practice. And again, I strongly recommend people reading this opinion, if only for Justice Alito's dissent, because Justice Alito's dissent describes how the Biden administration officials were really, daily phone calls to Facebook executives and others complaining about things on those platforms that were discouraging people taking the vaccine, for instance, or putting out information they viewed as misinformation. But it's pretty aggressive bludgeoning of the platforms. I mean, serious.
Yeah.
So but the problem is we didn't get to decide whether that was right or wrong because Justice Barrett decided there was no standing, and we didn't even have to decide it, or the court didn't have to decide it. Tell me about just that, how that decision got made, and then let's talk about Justice Alito's dissent.
Yeah, and your description of his dissent puts me back in mind when we were discussing earlier the bully pulpit. I mean, Alito would say they really put the bully in the bully pulpit here. Okay, so this case was a case, as you said, about the White House's and the broader Biden administration's interactions with social media platforms, especially Facebook, and especially around COVID-19 in the year 2021. And questions of whether the Biden administration's statements, private statements to the social media companies, caused the social media companies to take down speech by others. About a long time ago, in 2017, 2018, I wrote an essay for the New Atlantis at the very front end of these debates, long before COVID, where I argued that some of the hardest questions going forward in government politics would be about, especially the executive branch, leaning on social media platforms to police information, misinformation, disinformation. I called the essay Google.gov, which I meant as kind of a joke, but it seems more and more real every day sometimes. Now, as you said, the court ended up not reaching the merits of the case. The question was whether, in effect, the Biden administration had violated free speech rights of the individuals on Facebook. And Justice Barrett's opinion says there's no standing here. What she means by standing is under Article 3 of the Constitution, the Supreme Court and the federal courts can only hear certain kinds of cases and controversies. Those are the words in the Constitution. And for a long time, the Supreme Court has interpreted that provision to mean, among other things, the plaintiff has to have standing. If I'm going to sue you in federal court, whether you're the government or an individual, I have to be able to show that, first of all, I'm injured by the thing I'm complaining about. I have to show that you caused the injury. And I have to show that it's the kind of injury that the courts can actually remedy, whether through money or an injunction, anything like that. And here, because the allegations themselves, they don't show direct causation. It's almost impossible to show, really, unless you have statements from Facebook saying we wouldn't have taken this down but for the Biden administration's comments to us. Absent that, it's almost impossible to prove that something that Andy Slavitt or somebody else in the Biden administration says to some person inside of Facebook is enough to cause Facebook to take it down.
But is part of the reason that there wasn't standing is that the platforms themselves were not litigants? That if Facebook had been suing and saying our rights are being, but it was it was sort of one step removed, and that was a step far enough for Justice Barrett to say we don't have to address this.
Yeah, exactly. And oftentimes the platforms wouldn't say something like that. Maybe because they're worried about the broader regulatory environment. Again, not to keep bringing up analogies, but many years ago when I was still in private practice, I was a junior lawyer on a case where auto dealers, the companies that sell cars, sued the Obama administration over the very, very first round of greenhouse gas regulations for cars. And the D.C. Circuit dismissed our case. Attorney General Garland was the judge who wrote the opinion for the D.C. Circuit. He said, listen, it's not clear that these auto dealers have standing to sue. After all, the automakers, Ford and whoever, they're talking about how, they'd make these cars regardless of what the administration says. Everybody wants EVs. So therefore, you plaintiffs can't complain that your injury was caused by the Obama administration. This case, the Murthy case involving Facebook, is very similar in many ways to a case the court also decided out of New York called NRA versus Vullo, where the argument was the NRA sued saying that New York State violated its constitutional rights by leaning on, I think, insurance companies to not do business with the NRA to punish, in effect, the NRA for its speech. In many ways, those cases are very similar. The majority in Murthy did not think they were so similar. They did allow the New York case, the NRA case, to go forward, not this Murthy case. Alito thought the cases were very, very similar.
Yeah, so Justice Alito writes, what these events show, he's talking about the interaction. And by the way, the interaction we're talking about is very high level. It's the press secretary for the President of the United States, the high-level presidential appointees in in the CDC and FDA, calling Facebook executives at also a very high level and emailing them about posts that they thought ought to be taken down. So he's describing these events. What these events show is that top federal officials continuously and persistently hectored Facebook to crack down on what the officials saw as unhelpful social media posts, including not only posts that they thought were false or misleading, but also stories they did not claim to be literally false, but nevertheless wanted obscured. And this is the best part about Justice Alito's opinion. He really criticizes Facebook for how they reacted. And Facebook's reaction to these efforts were not what one would expect from an independent news source or a journalistic entity dedicated to holding the government accountable for its actions. Instead, Facebook's responses resembled that of a subservient entity determined to stay in the good graces of a powerful taskmaster. Facebook told White House officials that it would work to gain your trust. When criticized, Facebook representatives whimpered, says Justice Alito, that they, quote, thought we were doing a better job, but promised to do more going forward. They pleaded to know how they could, quote, get back to a good place with the White House. And when denounced as killing people, Facebook responded by expressing a desire to work together collaboratively with its accuser.
Yeah.
The picture is clear, Justice Alito writes.
This is my favorite kind of Alito opinion. I've always thought that his best function on the court, especially I guess when he's in dissent, this is a family policy podcast, so I'll say he's the court's best BS detector. He is really great at just cutting to the chase on things. Can I read one more quote while we're quoting Justice Alito's greatest hits here? This is earlier in the opinion. When he's comparing the court's holding in this case to that case, the NRA case, he says, what the officials did in this case, the Murthy case, was more subtle than the ham-handed censorship found to be unconstitutional in Vullo, but it is no less coercive. And then he adds, officials who read today's decision together with Vullo will get the message. If a coercive campaign is carried out with enough sophistication, it may get by. That is not a message this court should send. I've tried for a long time now to coin the phrase the passive-aggressive administrative state. It's the kind of administrative agencies where it's not so much about making rules or carrying out enforcement actions. It's about just pressuring companies like Facebook, like financial companies, to ostensibly do things on their own. In the modern administrative state, where any given company, but especially tech companies and financial companies, face so much regulatory pressure, whether it's for banks with the FDIC or the Fed, for tech companies, it's the FTC and other things. They face so much regulatory pressure that there's even more incentive than there would have been before to do these favors on behalf of the government with a smile on their face in the hopes that it might buy them some favor elsewhere in the administrative state.
Yeah, it's clear in Justice Alito's opinion that the government officials were not afraid to mention antitrust potential, pursuing antitrust issues or regulatory issues. It sort of let them know that, if you don't play ball here, you may run into trouble in another context. Yeah. But having said that, Adam, the only problem is let's say you're in the White House and there's an important matter before the public that's being undermined or influenced by misinformation, false information. Yeah. That's being posted on these great platforms. Yeah. If it was the New York Times, I presume you would have no trouble calling the New York Times and saying, hey, you got something wrong here, fix it. Yeah. Or CBS. But why do you think that the platforms deserve a greater protection from that kind of follow-up call from a press aide or someone just trying to get the facts right?
Well, I'm glad you're bringing this up because I don't want to give short shrift to the government's interest here. The government often reaches out either publicly or privately to speak the government's own mind. And there's enough of the justices have worked in and around the White House to understand that. And also, by the way, as a social media, I'm not on social media, but as a former social media consumer, I would rather be on a social media platform that took facts and information seriously. The reason why I'm not on Twitter is because it is like a hellscape of trash and lies half the time. And I just don't want that kind of thing. I think there should be a premium on social media platforms that actually take these things seriously. But the problem is I don't necessarily trust the platforms themselves to be the best definers of that. I also don't trust the government to be the best, and I worry about the government trying to shape those messages. So there isn't an easy answer here. And one last thing, I don't think, as much as I like Justice Alito and as much as I like his opinion, I don't think the majority opinion here by Barrett is on its face wrong. In fact, Justice Alito didn't dissent. He concurred in the judgment. So he agreed with the basic outcome of the case. He just thought the majority got the rest of it wrong, especially in its depiction of what had happened here. This is a good example of one of the themes that's flown under the radar this term is the ways in which the court really is tightening up the path to judicial review. In the FDA abortion pill case and other cases, over and over again, the court is really, while recognizing a lot of constitutional claims that haven't been recognized before, it is tightening up the path to judicial review. And I think Justice Barrett's opinion deserves a lot of credit. This is a really fascinating case, both in terms of the jurisdictional issues and in terms of the basic questions around this. And by the way, if readers want to learn more about the substantive issue, we did a whole series of essays. Remember, I think it's still up at platforms.aei.org with Christine Rosen and others thinking about the power of social media platforms today.
Okay, thank you, Adam, for that discussion of that case. That was fascinating to me. Now let's just finish up with some reflection from you on Chief Justice Roberts in this term. You've given it some thought. Is he hitting his stride? Is he asserting greater authority? Is he greater leadership? What's going on with Chief Justice Roberts?
It's a song from the '90s. Don't call it a comeback. I've been here for years.
Yeah.
This is the Chief Justice as the Chief Justice. You remember right after the Dobbs case 2 years ago, there was a lot of talk immediately that it wasn't actually the Roberts Court. The chief was no longer the chief. He was just along for the ride and often in dissent. And of course, he was in that case. I wrote a piece for the New York Times right after that saying it's ridiculous. Roberts was still at the center of the court more than just about any other justice, maybe right up there with Kavanaugh. And I pointed out at that op-ed that in the next few years, the court would be focused on race-based affirmative action and on the administrative state. And those are the two issues where Roberts is the most strident. And so, of course, the affirmative action cases were last year. This year, more than anything, was the year of the administrative state and the separation of powers. And over again, you saw Roberts writing opinions and writing them in a very Roberts way. I think we discussed in the previous episode the way that Roberts structured the immunity case and really built out this framework to try to send some clarity while admitting that there's always going to be hard cases in the middle. I think that Roberts didn't necessarily hit his stride. He just maintained his stride, regained his stride. This was very much a Roberts Court year.
But is strident really the word you want to use there, or do you want to use a word more like strong, just emphatic, leading?
Well, what I meant by that, I'm glad you asked. What I meant by that was there are a lot of places in the law where Roberts has counseled for a case-by-case path, very much, focused on stare decisis. And on these issues, the affirmative action and the administrative state, he's been much more energetic, choose your own.
To use judicial power.
To use judicial power.
Or use the power of the court to set the standard,
Yeah.
say what the law is.
Yeah, and part of that is because a lot of these issues are issues where there just isn't as much precedent, so the immunity case, or it's an area where Roberts clearly thinks the precedent has proven untenable, like the Loper-Bright case. But this really, I'm not sure how the numbers work out. Kavanaugh seemed to be in the middle a lot. So was Barrett. A lot of commentators on the left had a lot of nice things to say about Barrett at the end of the term. It reminded me of the term strange new respect. They used to say that every once in a while a new conservative judge would get strange new respect from Linda Greenhouse or someone else for ruling in the other way. But this, I continue to think that Roberts is a fascinating justice in the middle of the court, along with Barrett and the others. Okay,
so last question. I'm tired of the left-right controversy, but what's interesting to me about this court is the internal divisions and tensions among the justices that are called more conservative. And I thought in this term those seem to have quieted down, and they've sort of found a good way of operating within each other and disagreeing respectfully, and mostly agreeing. But am I wrong, or are there some real divisions between Kavanaugh, Roberts, Gorsuch, Thomas, and Alito, how embittered is Justice Alito when he doesn't carry the whole court?
Oh, I don't think he's that embittered. I think he's a happy warrior.
Yeah.
And this feels like something we discussed last year this time or the year before.
Yeah.
But when we watch the courts, we have to think in terms of both their jurisprudential method, like what are the tools they're applying to actually read the law, and also their willingness to overturn precedent, sort of go further, and that continues to be interesting. This year did show some more really interesting methodological disagreements between Barrett and some of the other conservatives in terms of how textualism actually works. And that's going to be very interesting to see it play out. Remember, before she was Justice Barrett and Judge Barrett, she was Professor Barrett, where she was a great scholar of textual interpretation. So that's going to be really fascinating. I'd say, I know we're talking about the conservative justices here, but just to remind folks, even in some 6-3 cases, you had interesting lineups where Justice Jackson came over to the along with the conservatives, or you'd see Barrett or Gorsuch on the other side. And so it's been interesting. The rhetoric in some ways has ratcheted up, right? The Justice Sotomayor's sort of increasingly prominent one-line zingers in her dissents. The president is now a king. You can't criminalize sleep, that kind of thing. That's ratcheted up, but I think on the whole, the court remains very, very cohesive.
All right. Well, so I wasn't going to bring this up again, but I have to come back to Trump versus United States because you used the phrase textualist.
Yeah.
And I was talking to a colleague of yours, also a constitutional law scholar, and he was talking about Trump versus United States and used the term originalist.
Yeah.
And he said emphatically that is not an originalist opinion. There's not enough in the Article 2 of the Constitution to justify all of that language. And I wanted to know how you react to that.
I bet I know who you're talking about, and I will keep arguing with him about this at breakfast. I just disagree. I mean, it's clearly an originalist, to begin with, an originalist opinion, the immunity case. It's beginning with trying to understand the original intentions of that undergird the text of the Constitution. But I also think it's a textualist opinion. It is the immunity case begins with a consideration of the president's executive power and all of his other responsibilities. Yeah, the immunity is an inference that we're drawing from the text, just as I think I said last time, Congress's subpoena power is an inference we draw from the text of Article 1 of the Constitution, and judicial review is an inference we draw from Article 3's judicial power. But it is about the text, and I think a lot of my friends who say this is not a textualist because there's no
specific reference,
no specific clause, that's not how textualism need be done, and I think this was a good textualist opinion.
Okay, with that, thank you, Adam White, very much, and we'll see you next time.
See you next year.